Hey, Kadeisha, it's good to see you today.
Good to see you too, William. I know that you have represented utilities in the power allocation space where there's contested rights for to serve customers. Could you tell me a little bit about that?
Sure, we've all heard the phrase, the customer is always right, and generally that's good marketing. But unfortunately, when you're dealing with a rate-regulated utility, you want to make sure that you don't duplicate transmission lines, and nobody wants to see 5 sets of transmission lines or 3 sets of distribution poles in their neighborhood. And so what the Public Service Commission does in Georgia and other states is regulate the way that that power is being distributed to various customers. So it's what we call the Territorial Act in Georgia, but other states have a similar type of way of allocating power so that you don't have the duplication of service, but at the same time you have good coverage that's available to every customer, whether they be residential or industrial. So that's the reason we sort of have this Customer Choice Act. And generally what that means is the customer doesn't have a choice, which is the customer is served by whatever utility happens to be assigned to the territory in which they locate. But there are certain circumstances where you find that the customer could be potentially served by more than one particular utility. Sometimes you have transmission lines that their territories are very close to one another, or something they call corridor rights, which means that there are pre-existing lines that run up into another utility's territory. And so for those reasons, the law looks at certain special circumstances, and usually it looks at the load that's being served by a particular customer. So we're not talking about mom and pop shops. We're talking about large grocery store type operations that, at least under the Georgia Act, is 900 kilowatts or larger. And those particular customers, if they are new service, are allowed to have a choice about how they want to go about providing those kinds of services.
And why is it important for utilities and businesses to be thinking about customer choice as it relates to their electric service supplier?
I'm really glad you mentioned both utilities and businesses because we've represented both. In the utility space, there are often disagreements between the utilities about who has that right to serve. And so there are different standards that come up that are applied. And so a lot of times we'll advise utilities when they're going into a marketing effort to determine whether or not this is a potential customer choice load or not, or if it's in their territory, to help them say, you know what, this is our load, you can't serve it. So we can help them in that way. But then sometimes after there is a customer choice decision made, then there is a dispute that arises out of that choice. And we can sometimes be involved in helping businesses who are the customer, because what happens is that they inevitably get drawn into these disputes. Usually it's on behalf of the utility that they want to serve their load. So it's sort of 2 against 1. And so sometimes we have the business, sometimes we don't, but sometimes we also represent the business individually. And it's ironic in the small world department that we actually had a case back when you were serving as a law clerk for a judge in this area. So you've now seen it from both sides, from what it's like to manage one of these cases and also working as an associate at Troutman Pepper on those types of procurement cases. So why don't you give us a sense of kind of what are the nuts and bolts related to this kind of practice?
Yeah, sure. Some of the things that you've seen, I think you touched on the load requirement for customer choice, and that being 900 kilowatts or greater. Some of the issues come when you're building a new property and you have to estimate that your load is going to meet the 900 requirement to actually be able to decide who your electric supplier is. And so, those are the type of issues that we'll see where you'll estimate, but the customer does not actually in practice use 900 kilowatts of energy or power. And of course, the utility that's servicing that area that may not have been selected by the customer is going to want to be able to service them because in fact they are authorized to do so under the law. So those type of issues arise. You also see issues with grandfather rights. Under Georgia's Act, and I'm sure other similar states have something where current suppliers of electricity to certain premises get to exclusively service those premises regardless of the territory that they're in. Issues can arise there because there's an exception to that grandfather right, where if a property has been destroyed, dismantled, and not reconstructed in substantial kind, then that customer now has the choice again. So those grandfather rights do not apply in those situations. Whether something has been dismantled and destroyed and not reconstructed in substantial kind is a fact-specific inquiry, of course. And the good thing is that the Public Service Commission, which has jurisdiction over disputes regarding customer choice, over the years has reviewed a lot of cases and made a lot of decisions that have helped to clarify that area of law and explain what does it mean to actually be reconstructed in substantial kind and when those exceptions actually do apply. So those are the type of issues that we're seeing. How can Troutman Pepper help with utilities and businesses as it relates to customer choice?
Well, usually it can take the form of a couple of different ways. One way would be when a utility is looking at serving a new customer and just trying to figure out whether it is a customer choice load or not. We've got very strong energy lawyers who can look at the questions of load profiles. For example, we have situations that a lot of customers now are using robotics and other kinds of heavy electric draw equipment. And even now, we're looking at the question of whether or not you can assemble a load like EV charging stations, putting batteries together. Does that reach that threshold of the 900 kW that you talked about? So we can help in advising utilities as to whether or not they should try to compete for a load or not. And then if for any reason that load goes to another utility, we're able to then work with them. And you described the procedure of the Public Service Commission.
Yeah.
You typically start before a hearing officer, and then you would take an appeal of that if you were not successful to the full Public Service Commission. You can then take that appeal to Superior Court, which is where you are a law clerk.
That's right.
And then from there, you can even go to the appellate courts. And we've handled those kinds of matters all the way up that chain, from hearing officer through the Georgia Supreme Court in some cases. So we can really work with clients in making sure that they not only understand their rights on the front end, can best position themselves to either get a load or protect that load if they were selected by the customer. And then lastly, we can always help clients defend that position in court if it becomes necessary, because those litigation skills are readily transferable. And we work as a team between the energy lawyers and the litigation lawyers to make sure we've got both the subject matter expertise for energy and the trial skills necessary to make sure we can succeed in the courtroom.
That's awesome. Thank you.